Hello everyone. My name is Sampa Karmkar Singh. I am Assistant Professor at WBNUJ, Kolkata. Today we are going to discuss about inheritance and succession under Hindu laws. As in our country we don't have still the uniform civil code, so different personal laws have their personal laws related to succession and inheritance. Let us first discuss about what is the meaning of this term inheritance and succession is. Black's Law Dictionary defines inheritance and succession as the term inheritance has been defined as a property received from an ancestor under the laws of intestacy, property that a person receives by bequest or devise. The dictionary further defines succession as the acquisition of rights or property by inheritance under the laws of descent and distribution. Inheritance may be termed as a means to an end, that end being succession. What are the kinds of succession? Succession is of two kinds. First is intestate succession. Second is testamentary succession. Let us now discuss about what is intestate succession. When a person dies without making a valid will, based on the religion of the deceased, the property owned by him or her is distributed following the common law of descent, applicable under his or her personal law. It is also termed hereditary succession. Testamentary succession means when a person dies leaving behind a valid will that states how his or her assets and property should be distributed after his or her death. Now, as this presentation is related to Hindu laws, let us discuss about what is inheritance under Hindu law and how it can be classified. There are actually two categories. First is the traditional system, second is the statutory system. Two prominent schools of Hindu law is first is Dayabhaga, second is Mitakshara. So under the traditional system, these two prominent schools of Hindu law were there. And Dayabhaga is applicable in Bengal and Assam. However, Mitakshara school is applicable in the rest of India. Coming to what these two schools are about, the Dayabhaga school has based its law of succession on the principle of spiritual benefit. Now, what is this spiritual benefit? This is entailing that those who could impart maximum spiritual benefit to the deceased, they would succeed. However, the Mitakshara school is based its law of succession on the principle of propinquity, meaning that those nearer in blood relationship would succeed. Mitakshara coparcenary. Under the Mitakshara school of law, three generations of male from the last holder of the property constitute Mitakshara coparcenary. Coparceners are related to each other either by blood or adoption. So, to be a coparcener in a family, you have to take birth in the family or you should be adopted by that family. Coparceners acquire a right in the ancestral property by birth, and doctrine of survivorship is also applicable to Mitakshara coparcener. Now, this is interesting that when a child takes birth in a Mitakshara family, where this Mitakshara school of law is applicable, then the coparcenary constitutes of actually four generations, right? So if you count it from the last holder of the property, after that, the next three generations. So it will make the four generations, right? So they will be the coparcenary. And the members who are part of this coparcenary are known as coparceners. Coming to this concept of doctrine of survivorship, though this concept has now become redundant after the 2005 Amendment Act of the Hindu Succession Act, but this concept you need to know. The doctrine of survivorship means that on the death of a coparcener, the property does not pass to other coparceners by succession. Instead, the probable share of other coparceners increase with every death in the coparcenary and decreases with every birth. Let me clarify it through the help of an illustration. Suppose X has three sons, then their share will be 1/4 each because X will have 1/4 share in the property and the three sons, they will also have the share in the property and all are equal. So there are four numbers here, X plus three sons, so total four. So they will get 1/4 each. Now suppose if one of the son dies, then their share will become 1/3 because now there is X plus 2 sons because one is dead. So now the share will become 1/3. Means the share increases with every death in the coparcenary. Second situation can be if suppose one more son takes birth in that family. In that case, the share would be 1/5 because X is the person and he has previously 3 sons. Now, after the birth of one son, it is 4 sons. So 4 plus 1, it is total 5 members, right, in the coparcenary. So they will get 1/5 each, right? So the share decreases with every birth in the coparcenary. Coming to the Hindu Succession Act 1956. Hindu Succession Act is applicable only to Hindus, as the name suggests it is Hindu succession. And it is mentioned also under section 2 of this act. It defines the term Hindu. It has been broadly defined under this act, under section 2. Few religions are included and few religions are excluded from the ambit of this act. For example, any person who is a Buddhist, Jain or Sikh by religion, this act applies on them irrespective of the fact that they belong to different religion. It considers Buddha, Jain or Sikh religion. However, this Hindu law is applicable to them. However, when we talk about Muslim, Christian, Parsi, Jews, they are outside its ambit and application of this enactment. Coming to the most important question, because it is about Hindu laws and Hindu Succession Act, on whom it is going to apply means who are Hindus. Any person who is a Hindu by religion, including a Veerashaiva, a Lingayat, or a follower of the Brahmo, Prarthana, or Arya Samaj. Any person who is a Buddhist, Jain, or Sikh by religion, and any other person who is not a Muslim, Christian, Parsi, or Jew by religion, unless it is proved that any such person would not have been governed by the Hindu law. It further explains, if you read this provision, the following persons are Hindus, Buddhists, Jain, or Sikh by religion, as the case may be. First is any child, legitimate or illegitimate, both of whose parents are Hindus, Buddhists, Jain, or Sikh by religion. Second is any child, legitimate or illegitimate, one of whose parent is a Hindu, Buddhist, Jain, or Sikh by religion, and who is brought up as a member of the tribe, community, group, or family to which such parent belongs or belonged. It further explains any child, legitimate or illegitimate, who has been abandoned both by his father and mother, or whose parentage is not known, and who in either case is brought up as a Hindu, Buddhist, Jain, or Sikh, and any person who is a convert or reconvert to the Hindu, Buddhist, Jain, or Sikh religion. So this is what the definition of Hindu says under the Hindu Succession Act. One interesting question is, does Hindu Succession Act 1956 apply to the members of scheduled tribes? Are they coming under the ambit of this act? The answer is no. The Hindu Succession Act does not apply to the members of any scheduled tribe within the meaning of clause 25 of Article 366 of the Constitution of India, unless the central government by notification in the official gazette otherwise directs. So it will be depending upon the fact that what the central government has notified. If it has not notified, in that case, directly this act will not be applicable to the members of scheduled tribes. Now coming to the definition clause. The definition clause provides lots of definition, but for the sake of this Hindu Succession Act, these few terms you will find in every more or less throughout this enactment, you will find these terms. And you need to know that what is the concept of full blood, half blood, and uterine blood. What are they? Who are they? How they are connected? So section 3(1)(e), it defines full blood, half blood, and uterine blood. First, we'll discuss about what is full blood. Two persons are said to be related to each other by full blood when they are descendant from a common ancestor by the same wife. So suppose A is the father, B is the mother, C and D are one is the son, another is the daughter. So if this is the family setup, then C and D, they are connected to each other through full blood because both the parents are same, mother and father are same. Coming to the next situation, two persons are said to be related to each other by half blood when they are descendant from a common ancestor but by different wives. Now we are just giving some more twists and turns to the previous illustration. Suppose A and B are wife and husband, and they have two children, C and D, right? Now suppose the wife dies, B. After that, A marries E, another wife, okay? And then with her, with the second wife, he is having one child, F, okay? So the relationship between F, C and D, these children, all these children will be related to half blood. So C and D are full blood relation, but their relationship with F, the child from the second wife of their father, that is half blood relationship. Coming to the next part, two persons are said to be related to each other by uterine blood when they are descended from the common ancestress but by different husbands. The similar situation which we have discussed in half blood, just change here the ancestress. Ancestress means mother. Suppose children are born by two different fathers. Then in that case, and mother is common, then the relationship between these children will be they are related to each other through uterine blood. Explanation, it says ancestor includes the father and ancestress means the mother. Daughters as coparceners. Now we have discussed in our previous slide that what is coparcenary. Interestingly, prior to 2005 amendment, only sons, that is the male descendants up to 4 generations, had rights by birth in the coparcenary property because only the male descendants were treated as coparceners. A daughter was entitled to a right to maintenance, including marriage expenses and residence in the joint family home till she is unmarried. Daughters were made members of the coparcenary by the Hindu Succession Amendment Act of 2005. So this 2005 amendment was revolutionary because it has given the daughters the equal right as coparceners as sons are getting. Section 6, let us see that what this section says because the change were made in this section only, where through which the daughters they got coparcenary right. Section 6 says devolution of interest in coparcenary property. On and from the commencement of the Hindu Succession Amendment Act of 2005 in a joint Hindu family, which is governed by Mitakshara law, the daughter of a coparcener shall first by birth become a coparcener in her own right, the same manner as the son. Second is have the same rights in the coparcenary property as she would have had if she had been a son. Third is be subject to the same liabilities in respect of the state coparcenary property as that of a son, and any reference to a Hindu Mitakshara coparcener shall be deemed to include a reference to a daughter of a coparcener, provided that nothing contained in this subsection shall affect or invalidate any disposition or alienation, including any partition or testamentary disposition of property which had taken place before the 20th day of December 2004. So this is the date, and you have to see that how this change has came, and if the partition is prior to this date, in that case it is not going to affect, right? Coming to a few cases which are landmark in this regard. The first case is about Prakash and others versus Phulavati and others. This case came in 2016. The question which arose whether the right of a daughter to be a coparcener would be applicable to living daughters of a living coparcener. As on 9 September 2005, that is the date of enforcement of this Amendment Act of 2005, irrespective of when such daughters were born, or would the amendment in the section 6 of the Act 1956 be applicable to a daughter born after the state date. So it was related to the date when this Act came into being. This amendment took place on 9th of September 2005. So what is the status of the daughters from where the date will be calculated? The Supreme Court held that this right is available to daughters living on the date of the amendment, irrespective of the fact when they were born. There was another case, Dhanamma alias Suman Surpur and another versus Amar and others. This case came in 2018. In this case, a suit for partition was instituted in 2002. During the pendency of the suit, Section 6 of the Hindu Succession Act 1956 was amended in 2005. The trial court decreed the suit in 2007. And interestingly, the daughters they got the benefit of this amendment in this case because The case was pending and partition suit was pending before the court. It was instituted, but it was not finally partitioned. So that's why the 2005 amendment, which came in between this date of partition suit and the date when it has been finally the suit was decreed, the partition suit was discussed and the court given the decree. That time in between this 2005 amendment came. This case is very interesting because this is in between the phase of the 2005 amendment. So the case was instituted before 2005 and decided after 2005. By this, the daughters, they got the benefit of this 2005 amendment. Next case is Vinita Sharma versus Rakesh Sharma, 2020. This case came in that year. The Supreme Court ruled that the amendment granting equal coparcenary right to daughters is retroactive, meaning it applies from the date of birth of the daughter and not from the date of the amendment. Coming to the general rules of succession in case of male. Now, let me here clarify to you all that we know in our constitution it provides equality. Even we have discussed section 6 where the son and the daughter, they got equal coparcenary rights. However, it is interesting to note that under the Hindu Succession Act, there are two separate sections which governs the rule of succession in cases of male and female. In cases of male, it is section 8. In case of female, it is section 15. Let us first see that what section 8 says. The property of a male Hindu dying intestate shall devolve, firstly, upon the heirs, being the relatives specified in class 1 of the schedule. Secondly, if there is no heir who is of class 1, then it moves to class 2 heirs. Thirdly, if there is no heir of class 1 and class 2, in their absence, it moves to agnates of the deceased. And lastly, if there is no agnate, then upon the cognates of the deceased. Class 1 heirs. So we have seen that the first priority in case of a male Hindu dying is intestate, means without making any will, is given to the class 1 heirs. It is very important to note that who are constituting this class 1 heirs. That list, it is provided in the schedule which is attached with the Hindu Succession Act. Class 1 heirs provides that list. It starts with son, daughter, widow, mother, son of a predeceased son, daughter of a predeceased son, son of a predeceased daughter. Predeceased, it means that the person has died before the father. Suppose if it says son of a predeceased son, it means that the son of the previously died son during the lifetime of the father. And we are here talking about, suppose the property of the father is there. So the relationship of this father with this son of the predeceased son is of grandfather and grandson, that relationship. But it does not uses the term grandson. It uses the term son of a predeceased son. Means the grandson will come into picture under the class 1 here only if the son is dead. So you could see that in very beginning it starts with son. In the absence of son, son of the predeceased son, he becomes class 1 here. Similar fashion, daughter of a predeceased son, son of a predeceased daughter, daughter of a predeceased daughter, widow of a predeceased son, son of a predeceased son of a predeceased son, daughter of a predeceased son of a predeceased son, widow of a predeceased son of a predeceased son, son of a predeceased daughter of a predeceased daughter, daughter of a predeceased daughter of a predeceased daughter, daughter of a predeceased son of a predeceased daughter, daughter of a predeceased daughter of a predeceased son. So this, if you want to make a table, you will get that in case of daughter of a predeceased daughter or of a predeceased son, means the son is dead, his daughter is also dead, and this is the daughter of this predeceased daughter of a predeceased son. So that way you have to identify that who this person is, because class 1 here you will see again the 4 generations are coming into picture here. Class 2 here, it starts with the first entry, which is father. Interestingly, students, class 1 here, mother is your class 1 here, but father is not the class 1 here. And interestingly, in the presence of father and mother, suppose there is a son and he dies leaving behind property and he has not made any will, and he left behind his mother and father. In such a scenario, Mother is class 1 here, so she will get everything and father will get nothing. However, if suppose mother is dead, in that case, father will get the entire property because he is in entry 1 of the class 2 years. The second entry says son's daughter's son, son's daughter's daughter, brother, sister. Then next is daughter's son's son, daughter's son's daughter, daughter's daughter's son. Then daughter's daughter's daughter. The fourth entry says brother's son, sister's son, brother's daughter, sister's daughter. The fifth entry says father's father, father's mother. Sixth entry says father's widow, brother's widow. Seventh entry says father's brother, father's sister. Eighth entry says mother's father, mother's mother. Ninth and the last entry says mother's brother, mother's sister. Now here, generally you will presume that father's widow is the mother. However, here you can see the two categories. Mother is class 1 here, but father's widow is class 2 here. So here you could think of the stepmother which are coming into picture. Right, students? So class 2 years, entry number 6, if you see, it says father's widow. So here father's widow is not your own biological mother. It is the stepmother. Okay. Finally, the explanation part in this schedule, references to a brother or sister do not include references to a brother or sister by uterine blood. Coming to agnate and cognate. Section 3, subsection 1a, it defines agnate. One person is said to be an agnate of another if the two are related by blood or adoption wholly through males. Section 3(1)(c), it talks about cognate. One person is said to be a cognate of another if the two are related by blood or adoption, but not wholly through male. Now let me clarify it with the help of an illustration. Now agnate is where you could see it is a relationship wholly through male. And in case of cognate, it is not wholly through male. Means there is a female intervention. Let me give you one example. Your father's brother's son, means your uncle's children, they are your cousins. They are connected to you as agnate because the connection is through male. Your father is a male, your uncle is a male, and their children, right? So it is connected wholly through males. However, the cognate may be, suppose your father's sister, she also has two children. So your relationship with the children of your father's sister is of cousins, but they are connected to you not wholly through male because your father's sister is a female. So these children are connected to you as cognates, and agnates will get preference over cognates. Okay. Coming to section 15, it talks about general rules of succession in the case of female Hindus. The property of a female Hindu dying intestate shall devolve firstly upon the sons and daughters, including the children of any predeceased son or daughter and the husband. Secondly, upon the heirs of the husband. Thirdly, upon the mother and father. Fourthly, upon the heirs of the father. And lastly, upon the heirs of the mother. Section 15, subsection 2 provides that the property will revert back to the original sources, meaning that any property which is inherited by a female Hindu from her father or mother shall devolve in the absence of any son or daughter of the deceased, including the children of any predeceased son or daughter, not upon the other heirs who are referred in subsection 1 in that order specified therein, but it will go to the heirs of the father. Okay, means her father. And second is any property inherited by a female Hindu from her husband, suppose from in-laws or husband, she has inherited something. In the absence of any son or daughter of this deceased female, including the children of any predeceased son or daughter, not upon the other heirs who are deferred in subsection 1 in that order is specified therein, but it will move to the husband's family. So if whatever she has inherited from her father, mother, that will revert back to that family in the absence of children or child of a predeceased child. And in case of if she has inherited it from her in-laws or husband, it will revert back to the in-laws or husband, their family, in the absence of son or daughter or any child of predeceased son or daughter. A case in this regard is Om Prakash versus Radhacharan. In this case, a woman became a widow within 3 months of her marriage, after which she was driven out of her matrimonial home. She went to her parents' home, received education, and got employment. On her death, she had various bank accounts and provident funds in her name. Her mother filed for a succession certificate. However, the courts denied her claim, as according to Section 15 of this Act, husband and heirs of the husband have a prior claim over a married female intestate's property. Since it was the self-acquired property of the deceased, Section 15 subsection 1 was applicable, and therefore the mother was not eligible to inherit the property of the deceased. It is the in-laws who inherited in this case. Consultation Paper on Family Law Reforms 2018. It is a report which was presented by Law Commission of India. It has also provided that equal rights of Hindu women over property will remain a distant dream till the legislature overhauls the succession scheme under the 1956 Act. There is no rationale behind providing separate succession scheme for men and women. Section 18 talks about full blood preferred to half blood. Heirs related to an intestate by full blood shall be preferred to heirs related by half blood if the nature of the relationship is the same in every other respect. So we have earlier discussed that who are connected through full blood, who are connected through half blood. You just have to see that full blood relationships they prefer over the half blood in cases of succession laws. Section 20 talks about right of child in mother's womb. A child who was in the womb at the time of the death of an intestate and who is subsequently born alive shall have the same right to inherit to the intestate as if he or she has been born before the death of the intestate, and the inheritance shall be deemed to vest in such a case with effect from the date of death of the intestate. So, here the only condition is that the child who was in the mother's womb at the time of death of the intestate, means the person whose property we are talking about, that this child in mother's womb should definitely born alive. If the child is not born alive, this provision will not apply. So you have to see that the child who was in the womb subsequently born alive. Coming to section number 21, it talks about presumption in cases of simultaneous death, where two persons have died in circumstances rendering it uncertain whether either of them, and if so, which, survived the other. Then, for all the purposes affecting succession to the property, it shall be presumed, until the contrary is proved, that the younger survived the elder. So, as you could see that it starts with the term presumption. Presumption in cases of simultaneous death. So, the presumption of the court would be that the younger has survived the elder. Let me clarify it with the help of an illustration. Suppose the father and son both died in a plane crash. Now, if it is very difficult to find out that who died first. So it would be presumed that the father died earlier than the son, because the rule says that the younger survived the elder. Section 25, it talks about disqualification. Murderer disqualified. A person who commits murder or abets the commission of murder shall be disqualified from inheriting the property of the person who is murdered, or any other property in furtherance of the succession to which he or she committed or abetted the commission of the murder. So if he has murdered someone, his property this person cannot get. Or if there is abatement of the commission of murder, then that will be also he becomes disqualified. However, it does not mean that this person cannot inherit from other people. He can definitely inherit from other person's property, but not from this person's property whose on whom he has committed either murder or he has abated the commission of the murder. Section 26 talks about converse descendants disqualified, where before or after the commencement of this act, a Hindu has ceased to be a Hindu by conversion to another religion. Children born to him or her after such conversion and their descendants shall be disqualified from inheriting the property of any of their Hindu relatives, unless the children or descendants are Hindus at the time when the succession opens. This is very interesting because it does not disqualify the convert. Suppose A is a Hindu and he has converted into Islam. So A's right is intact, but after converting into Islam, he has married a Muslim girl and then have two children. These children are, or this Muslim wife, they are not eligible to get property from her previous property, which was in his Hindu family. But this convert's right is intact. The convert's descendants are disqualified. The convert himself is not disqualified. Section 28, it talks about disease, defect, etc. Not to qualify, not to disqualify. No person shall be disqualified. No person, correction. Section 28, disease, defect, etc. Not to disqualify. No person shall be disqualified from succeeding to any property on the ground of any disease, defect, or deformity, or save as provided in this Act or any other ground whatsoever. Coming to section number 29, which provides failure of heirs. It is also associated with the doctrine of estate. Now, what is doctrine of estate? If an intestate has left no heir qualified to succeed to his or her property in accordance with the provisions of this Act, such property shall devolve on the government, and the government shall take the property subject to all the obligations and liabilities to which an heir would have been subject. Coming to section number 30, it talks about testamentary succession. Any Hindu may dispose of by will or other testamentary disposition any property which is capable of being so disposed of by him or by her in accordance with the provisions of the Indian Succession Act 1925 or any other law for the time being in force and applicable to Hindus. So here, Indian Succession Act is being referred, right? So if a Hindu want to make a testamentary succession under Section 30 and he has left behind a will, the will take into effect as per the provisions which are mentioned under the Indian Succession Act 1925. Section 22 talks about preferential right to acquire property in certain cases. What is preferential right? It is just a right where you are getting preference to acquire certain property. Now, what are these property? Where an interest in any immovable property of an intestate or in any business carried on by him or her, whether solely or in conjunction with others, devolves upon two or more heirs specified in Class 1 of the schedule, and any one of such heirs proposes to transfer his or her interest in the property or business, the other heirs shall have a preferential right to acquire the interest proposed to be transferred. So, outsiders will not be preferred. It is from the family if they want and if they have interest in the property or business which one of the legal heirs they want to transfer, proposes to transfer, then the first preference will be given to the other legal heirs who are mentioned in Class 1. The consideration for which any interest in the property of the deceased may be transferred in the absence of any agreement between the parties be determined by the court on application being made to it in this behalf. And if any person proposing to acquire the interest is not willing to acquire it for the consideration so determined, such person shall be liable to pay all costs of an incident to the application. So this is again very interesting because if you have suppose consideration is the price. If the parties they have decided of any price with their agreement, or if the agreement is not there, in that case the court will determine the price. And in such cases, if afterwards one of the parties backs out to acquire, who was previously willing to acquire the property for that consideration, if he is backing out, in that case such person shall be liable to pay all the costs of that application. Coming to section 22 subsection 3, it is preferential right to acquire property to heirs who offer the highest consideration. Highest consideration because there can be a possibility that there are more than two or more heirs specified in Class 1 of the schedule, and both of them they want to acquire that interest which one of the legal heirs want to transfer, proposes to transfer. Now in that case, out of these two or more legal heirs, that heir who is offering the highest consideration for the transfer, that will be preferred. So it is in the cases where there are like more than one person who want to purchase that property. Coming to section 17, it is talking about special provisions respecting persons governed by Marumakattayaman alias Santana laws. System of inheritance in which descent is traced through the female line. That is matrilineal system of inheritance, where the mother is the head of the family and not the father. So we are residing in a male dominating patriarchal society. However, there are few portions of our country, few tribes in our country where you will find that they are governed by the Marumakattaim or alias Santana laws, where it is based on the matrilineal system of inheritance. So here the chart is also different. Firstly, upon the sons and daughters, including the children of any predeceased son or daughter and the mother. Second is upon the father and the husband. Third is upon the heirs of the mother. Fourth is upon the heirs of the father. And the last one is upon the heirs of the husband. So in general cases, we have seen that the heirs of the husband, they are in clause number B itself. But in cases of matrilineal system, they are at the last option they are provided. There were few major issues that inadvertently arose after the 2005 amendment. Interestingly, certain Class 2 heirs that has been promoted to Class 1 post the amendment in 2005 are not deleted from Class 2. This has resulted in duplication of certain heirs which featured in both Class 1 and Class 2, like son of a predeceased, daughter of a predeceased daughter. So it is daughter's son actually. Okay. So if you see Class 1 and Class 2, in both these places they are mentioned. In Class 1, it is mentioned as son of a predeceased, daughter of a predeceased daughter. But in Class 2, it is mentioned as daughter's son. Similar fashion, the next one is daughter of a predeceased, daughter of a predeceased daughter. That is daughter's daughter. Third is daughter of a predeceased son of a predeceased daughter. That is daughter's son's daughter. And the last is daughter of a predeceased daughter of a predeceased son. That is son's daughter's daughter. Coming to the next part, that is reverse discrimination. Two of the male descendants in the daughter's line are not listed as Class 1 heirs, while their female counterparts are so listed. This omission creates reverse discrimination against the male descendants. Discrimination against father. Father should be relocated from Class 2 to Class 1 as this relation is certainly closer than some of the existing relations who are provided in Class 1 heirs. Father's widow or stepmother. Father's widow as provided under Class 2 should be clarified to indicate stepmother and not real or biological mother who finds a place in Class 1. So this clarity is required. Coming to inheritance rights of the adopted child. A child in respect of whom an adoption order is issued by the court shall become the child of the adoptive parents, and the adoptive parents shall become the parents of the child as if the child has been born to the adoptive parents for all purposes, including intestacy, with effect from the date on which the adoption order takes effect, and on and from such date, all the ties of the child in the family of his or her birth shall stand severed and replaced by those created by the adoption order in the adoptive family. Succession rights of illegitimate children. The courts are trying to afford inheritance rights to children born out of wedlock as much as possible by interpreting the law liberally. The lack of a secular central law in this regard is conspicuous by its absence. Inheritance rights of illegitimate children. The 110 report, which came in 1985, it is a Law Commission report where Law Commission of India has proposed that the definition of child should include an adopted child in the case of anyone whose personal law permits adoption, second, an illegitimate child. Therefore, it is very important to include adopted children and illegitimate children within the ambit of definition of child to protect and safeguard their inheritance rights. Section 16 of the Hindu Marriage Act 1955. Legitimacy of children of void and voidable marriages. Section 11 of the Hindu Marriage Act provides void marriages. Any marriage shall be null and void and may be so declared by a degree of nullity if it contravenes any one of the conditions which is specified in clause 1, 4 and 5 of section 5 of the Hindu Marriage Act. Section 5 actually provides the conditions for a valid Hindu marriage. Section 5 subsection 1, this clause number 1, it says provides neither party has a spouse living at the time of the marriage. Clause number 4, it provides the parties are not within the degrees of prohibited relationship unless the custom or usage governing each of them permits of a marriage between the two. Clause number 5 says the parties are not sub-in-laws of each other unless the custom or usage governing each of them permits of a marriage between the two. Section 12 talks about voidable marriage. Any marriage solemnized shall be voidable and may be annulled by a decree of nullity on any of the following grounds, namely, first, the marriage has not been consummated owing to the impotence of the respondent, or the marriage is in contravention of the conditions which is specified in clause number 2 of section 5. Now, this clause 2 of section 5, it is related to giving valid consent at the time of marriage. Third is the consent of the petitioner, or where the consent of guardian is in the marriage of the petitioner was required. The consent of such guardian was obtained by force or by fraud as to the nature of the ceremony or as to any material fact or circumstances concerning the respondent, or the respondent was at the time of the marriage pregnant by some person other than the petitioner. So these were the grounds where uh, it will be treated as voidable marriages. Section 16, subsection 3 of the Hindu Marriage Act says, Section 16 provides that the children born of marriage, which are null and void under Section 11 or voidable under Section 12, are legitimate children. However, Section 16, subsection 3 states that such children will not have property rights in the property of any person other than the parents. Some cases in this regard are Jinia Kyotin and others versus Kumar Sitaram Manji. This case came in the year 2003. In this case, the Honorable Supreme Court observed that as per Section 16, subsection 3, the deemed legitimate children will have property right only in the self-acquired property of the parents. Then came this Revana Sidappa and others versus Mallikarjun and others, 2011. In this case, the court held that the relationship between the parents may not be sanctioned by law, but the birth of a child in such relationship has to be viewed independently of the relationship of the parents. A child born in such relationship is innocent and is entitled to all the rights which are given to other children born in a valid marriage. This is the crux of section 3, subsection 3. Therefore, if a child is deemed to be legitimate, his or her right cannot be restricted to inherited only self-acquired property of the parents, but he or she is also entitled to ancestral property. It is interesting to note that the legislature used the term property without specifying it to be ancestral or self-acquired. Then came this Revana Sidappa and another versus Mallikarjun and others 2023 case. This is the recent one. Children clocked with legitimacy under Section 16, subsection 3 of the Hindu Succession Act are to be considered legitimate for the purpose of partition within the branch of the father. They cannot claim property in the larger coparcenary, but once the larger coparcenary is partitioned, notionally or actually, and the property comes into the hands of the father, all his children, legitimate per se or illegitimate by reason of Section 16, subsection 3, have the same right in partition of this property in the hands of the father. Now, there is a difference between a legitimate child and a child who is conferred the legitimacy under Section 16, subsection 3. In other words, the only difference between a child who is legitimate and a child who is conferred with legitimacy under Section 16, subsection 3 is that after the death of the father, the latter cannot claim partition in the larger coparcenary, unlike the children who are per se legitimate. This limitation on their right ends once the father's share in the larger coparcenary is determined. In the share of the father, once determined and separated from the larger coparcenary, they have the same rights as children who are legitimate under Section 16. Child born out of a live-in relationship. Now the society is changing, and in our society, you might see that there are many cases where you will find that the children are born out of live-in relationships. It may be noted that children born in live-in relationships which are in the nature of marriage, that is long-term cohabitation of partners, they are deemed to be legitimate and therefore it would attract the legal fiction of Section 16, subsection 3. On the contrary, Children born of live-in relationship of a transient nature, that is of a short duration, which would not entail the presumption of marriage, would be outside the purview of Section 16. As such, a relationship cannot be categorized as either a void or voidable marriage. Coming to the future roadmap, the Parliament should enact a law to address the issue of legitimization of children born of live-in relationship that fail to reach the threshold of a deemed marriage. Further, such children should be entitled to inherit the self-acquired property of their parents. Coming to the concluding remarks, the Hindu Succession Act 1956, it governs the Hindu succession laws in India, and there are many provisions which are not equally applicable to male and female Hindus. The father is class 2 heir and mother is class 1 heir, which is discriminatory. Parents should be kept on equal footing. There are two different provisions for Hindu male dying intestate under Section 8 and female Hindu dying intestate under Section 15. If both male and female are equal, then why two different provisions? The consultation paper on reform of family law 2018 also opined that gender gap in effective ownership is one of the most important reasons for gender inequality. Equal rights of Hindu women over property will remain a distant dream till the legislature overhauls the succession scheme under the Act 1956. There is no rationale behind providing separate succession scheme for men and women. The 2005 Amendment Act, while claiming to be a progressive with respect to coparcenary rights, grossly overlooked the fact that the primary scheme of succession under this Act of 1956 is in itself discriminatory. Now coming to few questions and answers. Question number 1 is, what are the prominent schools of Hindu law? Options are Mitakshara law, Deyabhaga law. Option number 3 is both A and B, and the last option is none. Here the answer is option number C, that is both A and B. So both Mitakshara and Deyabhaga are the prominent schools of Hindu law. Question number 2 says, what do you mean by uterine blood? Here, four options are available. The first option says two persons are said to be related to each other by uterine blood when they are descended from a common ancestor by the same wife. Second, two persons are said to be related to each other by uterine blood when they are descended from the common ancestor but by different wives. Clause number C says two persons are said to be related to each other by uterine blood when they are descendant from a common ancestors but by different husbands. And the last option is none of the above. Here the answer is very clear. In cases of uterine blood, we see that it is the mother is the common factor, father are different. So two persons are said to be related to each other by uterine blood when they are descended from a common ancestress, means the mother is same, but by different husbands, means the fathers are different. Question number 3 is, what are the general rules of succession in the case of Hindu male chronologically? So here you have to see that what section 8 says and the table how it provides the chronological order. The first option is class 1 agnate, class 2 cognate. Second option is agnate, cognate, class 1, class 2. Third option is class 2 agnate, class 1 cognate. Last option is class 1, class 2 agnate, cognate. So here the last one is the correct option, that is class 1, class 2 agnate and cognate. Coming to question number 4. What do you mean by the doctrine of ace cheat? The first option is if the intestate cheated someone from property right. Second is if the intestate has left no heir qualified to succeed to his or her property, such property shall devolve on the government. Third is if the intestate left his rightful heir disqualified. Sorry, if the intestate left his rightful heir qualified to succeed his property. Last is none. Here the answer is option number B, that is if an intestate has left no heir qualified to succeed to his or her property, such property shall devolve on the government. Coming to question number 5. Who are disqualified under the Hindu Succession Act 1956 from inheriting the property? First option is murderer disqualified. Second option is converts descendants disqualified. Third is disqualified on the ground of disease, defect, deformity. The last option is both A and B. So the answer here is both A and B, that is provided in option number D. So this is the correct answer. Thank you so much for the patient hearing. See you soon in my next video. Till then, bye bye.